how to handle an inquiry from the US Trustee program. Nobody wants it. No debtor attorney wants that letter in the mail, but it happens, and it's happening more and more now. Here with Larry Friedman, the former director of the US Trustee program, to give us guidance. Larry, you get a letter in the mail. What do you do?
Yes.
What do you do? Let's like because this is coming up. I'm hearing it more and more, especially now. What do you do?
Yeah. Well, the first thing you do is read the letter carefully because an initial inquiry from the US Trustee program has two components to it. One, generally, it can be resolved simply. The program isn't about playing gotcha. The program is about making sure that certain, in this case, consumer protection items in the bankruptcy statutes are, consumers are being treated fairly. So they're interested in seeing if consumers were treated fairly and getting compliance if they were not treated fairly. So the first instinct for people is, could be, oh, this is no big deal. I'll just tell them, you know, nonsense. The client knew what the fee was. There's no issue here. Have a nice day. That's probably not the way to deal with the complaint. A better way to deal with the complaint is to make sure that everything was done properly and quickly, if things were not done properly, fix them.
And when you say
So
fix them, you're
we
talking
we had we
fix the process or
well
reconcile it with that debtor.
well, you start with the complaint itself.
Okay.
So we had one yesterday. Someone got an inquiry from the US Trustee program. The inquiry dealt with a bifurcated Chapter 7 case.
Mm-hmm.
The inquiry was the fact that in the pre-petition filing agreement, it referenced the amount that was going to be charged in the post-petition agreement should the debtor choose to engage the attorney on the post-petition agreement. And the numbers didn't match. They were off by like $1,000. It had to do with the attorney who had edited the form, but didn't save it properly. So when he put the package together, the first form had one number, the second form retainer had a different number.
Mm-hmm.
Okay. So his inclination was to just call him up and say, hey, it was a typo. But the letter mentioned one other thing. The pre-petition agreement was entered into on a day in a month, say June 15th,
Mm-hmm.
and the post-petition agreement was entered into on June 16th.
Mm-hmm.
Okay. You can't file a bifurcated case and say, oh, we had this extra circumstances. We had to file the case, so we filed it right away on the 15th. And then we did all the work post-petition when you filed the pre and the post-petition agreements within 12 hours of each
Yeah.
other.
I mean, yeah. Oversight
So,
on the debtor attorneys.
right.
Yeah.
So understand, while the letter seemed pretty innocuous, they were really asking about the process.
Mm-hmm.
So you want to then go to the program and say, hey, the numbers were, I mean, it was a typo. It happens, right? It was a form thing. I made a mistake. And if they might accept that if they really think the debtor didn't understand, you might have to walk away from some part of that fee. Do it. Just appease them. Don't make that mistake again. Don't turn this into oh, we'll show you, or
Yeah, right.
oh, we really showed them, or boy, are they stupid because they couldn't see that this was just a typo. No, work with, answer the question.
Yeah.
But then the second thing is to recognize that they were really questioning your processes.
Mm-hmm.
And that's a different problem. So then, as you were referring to, go back and examine what your process is.
When you
For-
write the letter to the US Trustee program, I'm assuming this is a written letter, not a call, right? You don't call the US Trustee. I mean, that's probably
Right. But once you get the letter,
uh-huh.
you can reach out by phone and say, hey, I got this letter. Can we chat about this?
Okay. Would you
And try to
recommend that?
flood.
Is that something you recommend, like to sort of like
Oh,
open it up?
100%.
Okay.
100%.
Okay. So let's walk through this. Is you get a letter. The first thing is, like you said, read it carefully. Like read between
Yes.
the lines.
Try to understand exactly what the program is inquiring about.
And then second thing is call the program
Call
and just sort
quickly,
of like,
reach
hey,
out.
walk through it. All of a sudden, Shireen McNair talked about this on one of our videos about like she brought a humanity to it. It wasn't just letter, 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 right? And it really worked to her advantage. So you talk to them and you say, hey, can we talk through this? And you're going to learn a lot. Take notes, right?
Yes. Yes. They won't be shy about telling you what their concerns are.
Mhm.
Listen and see if there's any merit to their concerns.
Okay.
And even if there isn't, don't sit there and go, "Oh, that's ridiculous. Blah, 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 blah. We'll see what the judge has to say about that."
Yeah.
It's a bad attitude.
Humility is a
Yes.
key component when working with
Yes.
your trustee program, right?
Well, they are the United States Department of Justice.
Yes. I mean, have some humility. I mean, I had this conversation recently with an attorney who was going through this program, and I said to him point blank, "Hey, you know, have maybe a little humility would be good because it was just shocking how combative he was. Like, but they don't know this and they don't know this." I'm like, well,
Okay.
they're the program.
Okay. Well, then maybe we'll have to educate them.
Mhm.
But the first thing you want to do is if there's anything legitimate to their complaint, and there probably is. I mean, there are times, and I have seen, look, it's an organization of, it was at one time 1,100 people. It's significantly scaled back these days,
Yeah,
which is to the advantage of attorneys who get these inquiries because they don't have the resources they used to have.
right.
So they're anxious in a quick resolution.
Right. So let's go through this. You read the letter carefully, you call them, then you fix the problem
Yes.
that was fixed, that was the problem.
Yes.
And if there is a process problem, you fix the process. So when you send the letter back to them, so
Yes.
yes, I got your I understand that this is what you're concerned about based on our conversation on this date. I rectified it this way with the debtor, and I fixed our process internally the following way, right? Like,
Yes.
that would be a way for the trustee program to look at it and say, okay, these people are hearing me. They fixed the problem with the debtor and this, right? That's assuming that there is a problem and you just want to move on, right?
Yes.
Now, what if you disagree? The letter in
Yeah.
that case would be like, I hear your problem. I want to point out certain things to
Yes.
change, change the
Y
process. What advice would you give if if you're disagreeing with them?
Well, the first piece of advice I'd give is the same piece of advice that you would give, that's common in the legal industry. He who represents himself has a fool for a client. If
Okay.
you think that this is gonna go beyond this initial inquiry and you can't resolve it quickly, talk to someone. It doesn't mean hire counsel in every case, but talk to someone.
Mhm.
Get some perspective. Get an idea of what could or couldn't happen. How serious a problem is that? Then fashion your response.
Yeah.
I have seen these matters go to litigation. And even in that instance, and I'm talking big dollars, that the program thinks you've done a lot of things wrong and they think you've done it wrong 75 times and they want $100,000 back from you. Even in those instances, if you work with the program with good representation,
Mhm.
those matters get resolved.
Yeah.
And very rarely do you see something like this go to a hearing.
And very seldom have I ever heard in all these years talking to debtor attorneys, I'm talking specifically for debtor attorneys, do I hear these massive settlements.
Right,
Very seldom. I mean, it's
right.
like, oh, they're asking for 100,000 or whatever, or discharging 50 cases and one case gets disgorged, right? I mean, it's
Well, yeah, I've seen both. But
you
but
you've seen
it's
big, big, big disgorgements in
well,
terms of like,
I've seen demands for 300 plus $1,000, but the matter was resolved for, say, $50,000.
yeah.
So, I mean, it can happen, but, there are a lot of reasons that it gets complicated like that. But in every case, just work with the program and try to see what they're saying and try to address their issues. And if you can't, agree to disagree in a respectful manner and agree to a process where they get their fair hearing and the clients get whatever they're entitled to. And maybe, yes, maybe you have to suck up a little humanity in the process
Mhm.
sometimes. So sad, so sorry.
Well, I mean,
That
I
is
don't know if I'd call it sucking up humanity. It's like I call it like it's a virtue to
humility,
be
I'm sorry,
humble.
that mean
I
yeah, that's humility. Humility.
Hey, just a little humility. That's a good thing for
Yes,
everybody.
yes, yes, your audience should know how early it is on a Saturday morning that we're doing this.
There we go. Thank you.
They all get resolved, and they should.
Yeah. And one last question regarding these inquiries. How much is it a random spot check, or is it something where they're seeing things over time, right? Like, you know what I mean? Like I've always wondered this. Like, is trustee program just having someone, okay, we're pulling this file, we're looking at it. Oh, mistakes in a letter. Or is it like, we're hearing something, I'm seeing something, patterns emerging, trends happening. We're going to start watching this debtor attorney. And then when they actually give a letter, it's, there's more behind it than just this one case.
Yeah, it can be both.
It can,
It can be both, but in almost every instance, such as this one the other day,
mhm.
and that's a one-off thing.
It's the one.
Now, I don't know what triggered it, but I think that they have people that regularly review filings and things like this,
Mhm,
and there was a flag.
mhm.
I mean, the pre and the post petition
Yeah.
agreement had different numbers. That's
Mhm.
gonna get you an inquiry.
Yeah. One other question is I've heard of the program just showing up to 341s,
Yes.
right? And it freaks debtor attorneys out. Obviously,
Yes.
like, I mean, it's like, why are they showing up? Like, what's happening, right? Speak into that. What are your thoughts about that?